I am the walrus. I, I'm the walrus. Okay, here we go. And sharing screen. Advanced. Share slides. This will take a moment to set. I'm sorry. Okay, these will be starting momentarily. All right, so the topic today is Section 3 of the 14th Amendment. Now, when I went to law school, no one had even studied Section 3. It hadn't even been a thought in anyone's mind. But this has become a very significant issue in the last 3 years because of President Trump. So to start, the text of Section 3, I'm sort of blocking it, but here it is. The text of Section 3 does a lot of things. It's sort of very messy. Let me sort of break it apart to make it a little bit easier to understand. There are four primary components for this text, right? And I'm going to take them out of order. The first component is, who does Section 3 apply to? It applies to a person who took an oath as a member of Congress, or as an officer of the United States, or a member of a state legislature, or as an executive or a judicial officer of a state, right? So the basis of this provision is to say, if you took one of these oaths, you are now subject to certain rules, okay? What can't you do? You cannot engage in insurrection or rebellion. So if you took one of these other positions and then you engage in insurrection, something will happen to you. That's number three. You cannot hold certain offices. You cannot be a senator. You cannot be a representative. You can't be an elector. You can't be holding an office under the United States. But it's not a permanent disability. Congress can relieve it by a 2/3 vote, right? So the reason why this matters, of course, is January 6th, right? And in December, the Colorado Supreme Court actually took action to disqualify President Trump from the ballot. So there really are four questions that are presented in this case. The first is, can the Colorado Supreme Court disqualify Trump using its state election laws? The second is, did Trump's oath subject him to Section 3? Third, did Trump actually engage in insurrection? And fourth, is Trump disqualified from holding the presidency? But we can restate these questions a little bit differently, right? Why? First, does Section 3 require federal enforcement legislation, or can states enforce on their own? Second, Trump is unique. He's the only president who have taken oath without ever holding any other government office. He held no other foreign position. The only way that Section 3 applies to Trump is if he took an oath as an officer of the United States. We'll focus on that clause at some length. The next issue is, were the events of January 6th an insurrection? It's not obvious. The term is not clear, and no one has been indicted for insurrection anywhere. And the fourth question is the presidency a position to which you're disqualified in office under the United States? Okay. Now, you may not think much about this, but some people have. And my colleague Seth Barrett Tillman has been writing since 2008 that when the Constitution uses the phrase officer of the United States, it means appointed, not elected positions. We've all cited the Appointments Clause. We know what it means. The president appoints the officer of the United States. He himself is not such an officer. Okay. And around 2023, I was sort of Tillmanized. I was persuaded this position, 2013, I was persuaded the position was correct. That the president is not an officer of the United States. He is appointed, he's elected and not appointed. And people have agreed with us over time. Professor Will Bode at Chicago wrote that Tillman's theories make sense of patterns that most of us never saw. It brings order out of chaos. Okay. Why does this matter? Shortly after Trump took office, there were allegations that he was violating the Constitution. Why? Well, he had hotels. And those hotels catered to foreign governments in part. And it was argued that Trump's accepting profits from these foreign governments violated the Constitution's Foreign Emoluments Clause, which, again, no one ever heard of before 2017. And this provision says that certain people in the government cannot accept presents, emoluments, or titles from foreign governments. Okay. But look at the language. It only applies to a person holding any office under the United States. Right? There's this key phrase. If the president does not hold one of these offices, he's not subject to the provision. So between 2017 and 2021, Seth and I filed a number of briefs in court arguing that this phrase, office under the United States, does not include the president. We have evidence. George Washington accepted gifts from the French government. Thomas Jefferson accepted gifts from the Russian government and from the Indian tribes from Lewis and Clark's expedition. At one point, the Senate asked Alexander Hamilton, give us a list of people holding office under the United States. And the list he created did not include the president, did not include the vice president, focused only on appointed positions. Okay, we created a bit of a storm because some historians said that we were misquoting Hamilton. We ended up being correct. They apologized. Hamilton is on our side. It's a good thing to have. But eventually the emoluments cases went to the Supreme Court, and the court said, well, you know what? Trump lost the election. He's out of office. These cases are moot, and they got rid of the cases. Okay. So we thought we were done with this officer stuff because in 2016, Biden and Harris won the election. Trump was out of office. I'm sorry, 2020, Biden won the election. Trump was out of office, and no one cared anymore about emoluments. But then January 6th happened, right? And we were dragged back into it. Why were we dragged back in? Because Section 3 of the 14th Amendment only applies to Trump if he took an oath as an officer of the United States. And the position to be disqualified is the presidency in office under the United States. So our work on this issue of offices and officers became relevant right away. In fact, we realized on January 6th that we were going to be dragged back in to this officer stuff. If you ever see the movie Groundhog Day, not too far from Punxsutawney, wherever you guys are, we're stuck in this loop where we can't escape. So my colleague Seth and I, we wrote an article in the NYU Journal of Law and Liberty, arguing, by the way, this is like, the before and after, I kind of cover my own face up. So I'll go over here, a little bit easier. And we argued that the president is not an officer of the United States for purposes of Section 3. There's lots of textual evidence we talk about. There's lots of historical evidence, but we think this is a good position. It may not be intuitive, but one we think is supported by the weight of evidence. Now, our position, got some attention, but not very much. But then in August of 2023, an article by two prominent FedSoc members came out. Will Bode from the University of Chicago and Michael Stokes-Paulson from St. Thomas in Minnesota. And they argued that Trump should be disqualified, that virtually all the evidence favors removing Trump from the ballot. Now, it's not that this argument was right, is why it got so much attention. The reason why it got so much attention is because these were two conservatives. And as many of you probably know, when a conservative criticizes Trump, they get all the love in the world. They get all the attention in the world. It's just this delightful thing. I've never experienced it, but I've heard of it. But they get this attention because they're saying things that liberals like, and that's sort of an important part of advocacy today. Now, I don't think that's why Mike and Will did it. I think they believed in their cause, but the necessary consequence is they're given attention for that reason, not because of necessarily the merits of their argument. Okay, and Bode and Paulson argued that and they spent about a year studying this issue. It's a lot to study in a year, but they wrote this article about 150 pages saying that all the evidence points in the direction that Trump should be removed from the ballot. Now, again, Mike and Will are good friends, and I've known them for a long time. I still consider them good friends, but they didn't like our position very much. They said that my position with Tillman, the Blackmun-Tillman position, is, quote, hidden meaning hermeneutics that renders Section 3 a secret code loaded with hidden meanings, discernible only by a select priesthood of Illuminati. Now, maybe, you guys are going to a Catholic law school. You can tell me what hermeneutics is. I don't even know what that even means. But it's some sort of cult thing, I'm guessing, with the Illuminati. I can assure you I am not a member of a cult. I am not trying to indoctrinate you. There's no subliminal messaging. You are safe. But this is what they wrote about in their article. I will hand out secret decoder rings later so you can figure out our arguments. I think they're actually pretty straightforward. Amar and Bode were not the only ones. Akil Amar, who teaches at Yale, said, let me be clear. This is a genuinely stupid argument on the merits. I'm going to demolish it. It's embarrassing. This is very wrong. It's silly. It's so silly. And I was laughing because I was actually couldn't list blah, blah, blah. Yeah, he did not like our position. He spent a lot of time in his podcast talking about it, which is the reason why you should not listen to podcasts. It's not a good use of anyone's time. But then a funny thing happened. This case was being litigated, and a trial court in Denver agreed with us. Right? A trial court in Denver said that wait a minute, the president is elected. He's not appointed. He's not an officer of the United States. This is obvious, right? This was not a FedSoc judge. This was a Democratic appointed judge in Denver who found our arguments persuasive. So the funny things about this argument is I think elites who tend to have this very refined law school education think this is an obvious argument. And those who have a little more practical experience maybe say, well, that makes sense. Uh, what evidence did the court look at? The Appointments Clause uses the phrase officer of the United States for so appointed positions. The Impeachment Clause separates the president from the officers of the United States. The Commissions Clause says the president shall commission all the officers of the United States. The Oath Clause lists people who take an oath. The president has own oath in Article 2. Okay. Next, we walk through these provisions and all the evidence supports our position. Okay. So we won the trial court, but this went to the Colorado Supreme Court. And guess what? The Colorado Supreme Court rejected our argument. They didn't actually address any of our evidence. They kind of just said, oh, this is crazy. There's no way this works. It's hidden meaning hermeneutics, secret code, and so on. And they rejected it. Okay. At that point, once the Colorado Supreme Court ruled that Trump had to be removed from the ballot, this case was destined for the Supreme Court. In fact, the Supreme Court granted review right away. They put this super expedited briefing schedule, and it was slated for oral argument on in February of 2013, February 8th. I'm sorry, February 8th of 2024. Okay. Once again, Tillman and I filed a brief. We made two primary arguments, which I'll talk about. The first argument was about text, right? The framers of the 14th Amendment did not have someone like Trump on their mind, right? Again, just to lay this out clearly, in order for Trump to have been covered by Section 3, he would have to be an officer of the United States, right? That's his only oath he's ever taken. But the framers of the 14th Amendment were not thinking about a person like Trump. That is, a person who was elected as president, had never before taken any other oath, engage in insurrection, and then start re-election. This sort of fact pattern was not in their minds when they drafted the 14th Amendment. They had no reason to think about it. I think there's good evidence that whatever Section 3 means, they were not worried about the president being covered by it, right? Also, they weren't worried really about about a person becoming president. That's a slightly different argument. Okay. We presented our argument. Seth and I also asked for argument time. We were denied. Not surprising. I didn't think it was going to be granted. We mostly filed to sort of flag some issues and maybe put the court on notice that the lawyer for Trump would maybe not be what they were looking for. All right, so the case goes to the Supreme Court. I was there. I was sitting at the third row. Trump was not there, but he was there in spirit. Shortly before the case was argued, the New York Times wrote another article about my friend Seth, and it was Legal Outsider, an offbeat theory in the fate of the election. When the Supreme Court considers whether Donald Trump is barred from appearing on the ballot, a professor of scholarship, long relegated to the fringes, will take center stage. And then there we are with Seth. Okay, there we are at the Supreme Court. I kind of like this picture. We're looking up into the sky. And this is us between 2020 and 2024. COVID was not good to me. But that's how the world works. You'll get older, you'll see. So the oral argument focused at some length on this question about whether the president's an officer of the United States and is the presidency in office under the United States. Okay. And there were three approaches that came out during the argument from Justice Kagan, from Justice Jackson, and Justice Gorsuch. So the first approach was Justice Kagan, and she said, in other words, why would the framers have excluded the president from the 14th Amendment, right? Is this rule a sensible one? Does it make sense? That's not a very good originalist question, but it's about common sense. And I get that some judges really care about what they view as, by the way, common sense is not universal. What might be common sense for me is not common sense for you, but it's a judge's sense of what's right and wrong, right? The second one was from Justice Gorsuch, and he, I think, is probably the court's most, I don't say careful textualist, but the most committed textualist in the court. At least that's how he views himself. And he says, so maybe the Constitution to us today, to a lay reader, might look a little odd in distinguishing between office and officer. But maybe that's exactly how it works, right? In other words, Gorsuch is saying, Stop thinking about what makes sense to us today and look at what the text actually means. I think that's a good way of looking at it. And then you have Justice Jackson, who's my new best friend, who says that the history of the 14th Amendment provides the reason why the presidency may not be included. She's looking, they were not worried about the president. They were worried about lower level officials, right? That was what was on their mind. They were trying to get all these former Confederates to have state government. They weren't worried about the person becoming president or a former Confederate president being elected again. This is not something they were worried about. Okay. Now, curiously, the positions kind of line up. See that right there. Um, the Justice Kagan position was actually the position advanced by Will Bode and Mike Paulson. The Gorsuch position is what Seth and I argued, and actually the third one was from Professor Kurt Lash, who's a professor at the University of Richmond. Okay, let's move on. Right, Bode and Paulson say, for far more sensible and straightforward to conclude, we think that the office holder holding the president is an officer of the United States who holds office under the United States. Okay. But Gorsuch took a different position. He says it doesn't really matter what we might think today. What matters is what they thought at the time. Okay. I'll skip over this for a bit to get to the opinion. All right. But then at one point, Justice Sotomayor sort of talked about us. She said, I don't think this is right about, this officer of the United States argument. She says a bit of a gerrymandered rule because it only benefits one president, which is Trump. And then Sotomayor interrupts and saying, well, you didn't make this argument, but I know some scholars have been discussing it. And those some scholars were me and Seth. So I'm happy to have that on my side. So these are some scholars that have been in the game. And here are some more scholars. This is me with Bode and Paulson. All right. So that was the oral argument. And from my perspective, it seemed pretty clear the court was not going to disqualify Trump. It was not going to happen. The only question was, how would the court go about saving Trump? Right? How would the court going about saving Trump? They could have held, as we argued, that the president's an officer of the United States. They could have held, as Kurt Lash argued, that the presidency is not covered. They could have held that there was no insurrection. They could have held that Trump doesn't engage in insurrection. They could have held that Congress must enact enforcement legislation. The court could have held that the disqualification doesn't kick in till Trump actually tries to hold office, so it's moot. So it's not yet ripe. There are a lot of ways the court can do it. But how did the court actually resolve the case? It's what I've often called a John Roberts blue plate special. If you ever been to a diner, you know what I'm talking about. Where they sort of whip something together, they take a little bit from here, a little bit from here, they put it all together. What do you get? You get a ruling that doesn't make anyone happy, doesn't really make a lot of sense, but gets the result the court wants. And that's what I think about. Now, I think the decision is defensible, but has problems. Let me explain how it works. When a state is enforcing its election code, the state can impose whatever qualifications it wants on state officials. So if you're running for mayor of Philadelphia or sheriff of Lancaster County, right, or judge for the Commonwealth Court, right? I clerked in Pennsylvania. I remember this stuff. No matter what state position you have, the state can impose qualifications. If Pennsylvania said we do not want any insurrectionists to be governor, and we're imposing this as a matter of our own state law, they can do that, right? They don't have to rely on the federal government. Okay. Now, can a state impose qualifications on federal officials? So can a state say, we want to impose term limits on members of Congress? The Supreme Court said you can't do that in a case called U.S. Term Limits v. Thornton. You can't add qualifications for members of Congress. Okay? So that's the basic principle. But now we go a little bit further. Can a state enforce a federal qualification against a federal official? All right. The answer here may not be as clear as you think it is. So, for example, you have to be 30 years old to be a senator or 25 to be a member of the House. What if a 23-year-old, or let's make it easier, let's say a 19-year-old runs for Congress? Can the state keep him off the ballot? You might say, of course they can, Josh. It's not actually so clear because the Constitution says that the House is the sole judge of its own elections. So it's arguable that the states have no power to police the congressional ballot. Now, some states have done this without question, and it hasn't really been litigated to the Supreme Court. And maybe what happens, Josh, if a 17-year-old, runs for the White House, runs for the presidency? Again, uh, a number of states have allowed 17-year-olds on the ballot, and some states have taken underage people off the ballot. There's no judge of election clause. The president's might be a little bit different. But what about Section 3? Right? Section 3 different. Can state courts enforce Section 3 pursuant to their own local legislation? Maybe as a matter of first principles, you might think, well, what's the difference between being underage or not being a natural born citizen and being an insurrectionist? The distinction might be because we have a decision from Chief Justice Salmon Chase in 1869. Salmon Chase was the Chief Justice, and he had a decision on the circuit court, or riding circuit. And to summarize a long story short, he said that Section 3 requires federal enforcement legislation. Right? It was not an election context, it was in context of disqualifying a state court judge, perhaps, on a habeas review. But if you read Chase, what he's saying is states cannot, what he's saying is we need congressional legislation. Federal legislation is indispensable. It's necessary. All right. So if Chase is right, that might suggest that Section 3 is either different or requires a different level of enforcement. Now, the Supreme Court didn't actually come out and say, we are following Chief Justice Chase and we're going to apply his decision. We think it's correct. They cited it. They mentioned it. They didn't say it was wrong. They didn't say it was a terrible decision. They sort of mentioned it in passing. But I think if you look at what they did, they're following Chase. And here's what the court said. If the states want to enforce Section 3 against their own local officials, they can do that. They do not need enforcement legislation. But if a state is trying to enforce Section 3 against a federal official, elected or appointed, said both, then they need Congress to act. So what's the upshot of that decision? The upshot of that decision is Congress has not taken any action to enforce Section 3 against Trump or really anyone else. Indeed, the special counsel, Jack Smith, who gets a lot of press these days, he's not charged Trump with insurrection. He's not charged anyone with insurrection. So the argument goes that the states do not have the power to enforce this by themselves. So as a result, the Colorado Supreme Court decision was vacated. Decisions from Maine and other states fell apart. Trump will be on the primary ballot. He'll be on the general election ballot. So are we done? Not necessarily. Here is the rub. All the court said is that Congress needs to be the body that enforces Section 3. But Congress does have a say in this matter. On January 6th of 2025, we'll have a joint session of Congress. What happens at this joint session? Each House, the House and the Senate, will tabulate the electoral votes. They'll say, Alabama, right? Arizona, Arkansas, right? And they'll count the votes. So let's say they call Alabama and they say, Alabama has so many votes for Trump. And then someone raises their hand and says, I object. You object? What do you mean you object? I object. The votes given for Trump are not valid because they were not regularly given. Because he's an insurrectionist. He's disqualified. Wait a minute, didn't the Supreme Court hold he's not disqualified? No, they did not. Didn't say a word about that. All they said was states can't do it, but Congress can. So can Congress, through the existing Electoral Count Act, disqualify votes? I don't think they can. I think the Supreme Court said they probably can't, but it's not so clear. And I'm not sure you can even appeal from a Supreme Court decision from a joint session of the Supreme Court. But I'll assume that Congress does not try to DQ Trump on January 6th. Let's say he wins the election. What happens on January 20th of 2025? Trump will take the oath, so help me God, and then he takes an action. He fires someone. He takes an executive order. He issues a pardon. He does something. And then someone says, wait a minute, you can't fire me because you're not the president. You're disqualified. The real president is Vice President Haley or someone else. Who knows, right? You're not the president. Or Lord help us, the real president's really Joe Biden. He got reelected because you didn't have enough votes, Trump. Um, what the heck happens then? So there'll be some sort of emergency appeal to the Supreme Court, basically saying, who is the real president? At that point, the court might say, oh, this is a political question, but don't leave us alone, in which case Trump will be this like asterisk president where he's not really president for 4 years. We'll see how that goes. Or the court can say, aha, Blackmun and Tillman right about the officer stuff. The president's not covered. Or maybe J6 was not insurrection. Lots of ways it can go. But the court's punt on this issue from Trump against Anderson doesn't actually resolve this case. In fact, it makes things actually markedly worse, right? It leaves this issue simmering until the joint session of Congress, if Trump wins, or leaves us to January 20th if he actually becomes a certified candidate, certified president-elect. So I don't much care for the court's decision. I think they got the 14th Amendment right. I think you do need federal legislation to enforce Section 3. But the way the court did it, I think, is the worst possible way. Now, the vote was on paper unanimous. All 9 judges agreed that Colorado could not disqualify Trump. All 9 of them agreed on that. Okay. But the court sort of split 5-4, 6-3, and everything else. The 5 members of the majority said that Congress must enact very specific legislation to enforce this, suggesting that maybe Congress has not done it yet. I don't know if they have. Justice Barrett wrote this very weird concurrence saying, let's not decide that issue here. And oh, by the way, the 3 liberal justices, you're being strident. Sotomayor, Kagan, and Jackson. You shouldn't have dissented like this. We should have national unanimity, turn down the temperature, let's make America calm again, or something like that. I think in Justice Barrett's attempt to turn down the temperature, she actually made things substantially worse, but that's sort of how these things operate. Okay. So what do we take away from this litigation? First, I think there was this really strong urge by people to use the courts to achieve a political end. Whether Trump is president or not is a political question. It will not be resolved by the courts. And I think it's a mistake to try and see the courts as a way to accomplish these goals. The second, I think, major takeaway is that the court was never going to do this. It was always a pipe dream that John Roberts and his colleagues would actually take Trump off the ballot. And just to put things in perspective, this was a case that was viewed about democracy. I use scare quotes like, we need to keep Trump off the ballot to save democracy. And just pause that for a minute. The way to save democracy is to prevent people from voting for a candidate, right? That this is how we save the Republicans by taking the vote away from millions of Americans who want to vote for Trump. Again, he's the candidate of choice. It may not be the person I would pick or anyone else, but this is the guy who's winning the primaries hand over foot, and this is what people want to vote for. Don't tell them they can't vote for the candidate. I think a lot of law professors fell into the sort of trap of seeing this issue in this very narrow lens and get perhaps a little bit too excited. Okay. But just keep this in mind. As soon as Trump is elected, right? As soon as he actually gets into office, assuming he wins, which looks like it from the polls, there'll be litigation immediately over whether he's disqualified. So all this stuff I'm talking about will come right back to the fore. All right. I am at about 30 minutes. I'll be sensitive that I'm on Zoom, and I welcome any of your questions. Thank you so much.
So for questions, I'm gonna, select who speaks, just raise your hand and I'll pick you guys. Then you guys can like come close to the computer, like stand right there and just ask your question. So who wants to go first? Mike?
Thank you for coming, Professor. Appreciate you spending time and explaining this to us. I was listening to a podcast, which obviously you think is a waste of my time, but Charles C.W. Cook made the point that, and then was just reading through the opinion that the issue was whether they could remove Trump from the primaries.
Right.
And did they touch on whether he could be removed from the general election? Because at the end of the day, Trump was going to sweep through most all of the other primaries anyway, so the point would have kind of been moot. What would have happened if the Supreme Court didn't choose the way they chose, or if the Supreme Court would have just not taken this case and Trump would have been removed from the Colorado primary ballot, and then Trump would have won the primaries in the other state and become the Republican nominee?
Sure. So the Colorado Supreme Court decision actually applied to both the primary ballot and the general election ballot. It actually mentioned both of those ballots. And the reason why is that the election code basically applies equally to both. So if it was a violation of state law to put on one ballot, excuse me, it'd be violations from the other ballot. And the Colorado court actually said you can't even write the guy's name as a write-in ballot. I mean, Trump is not a hard name to spell. People could just write it in. You can't even have his name as a write-in ballot. So had the court simply said this case is not yet ripe because this is a primary ballot, or perhaps the court said there's a First Amendment right to select your party candidate, that would have made this issue come back in about 6 months or so. Not 6 months, actually about, yeah, November for the general election ballot. So I don't think they wanted to. Um, and the way I read the court's decision, this applies equally to primary in general. But I think the other risk was actually what's called holding office, right? Where this disqualification doesn't apply to running for office, applies to actually holding the office. So they could have actually held on to it till inauguration day, which is a scary, scary thought for when to resolve this issue. I'll just give you just one more wrinkle. Um, is there anything wrong with the state sending to electoral votes for a candidate who's disqualified? I mean, let's say Colorado says we want to put a 21-year-old on the ballot and we want to vote for him. I mean, they can do that. The votes won't be counted by Congress, probably. They can do that. So it's not clear any of this is actually ripe yet. I've always used it as a ripeness argument rather than a standing argument. But that's it. To answer your
Thank
question. And I know Charlie Cook, it's a good podcast. I like to read and I can read so much faster than I can listen. Would you have a long commute you usually listen to these on? Is that what you do, or Jim?
Yeah, I drive an hour to school every day. So
Where are you driving from?
I'm from Coatesville, so it's about an hour away from Villanova, about
Uh,
halfway between here and Lancaster.
yeah, I think they mentioned this in my bio. I went to Penn State and I clerked in Johnstown, Pennsylvania for 2 years. So I spent a lot of time in Pennsylvania.
Oh yeah, John, where the flood happened.
Exactly. It's funny. I was looking for an apartment in Johnstown. I got one on top of a very tall hill. I'm like, okay, good. I'll be safe. The water comes back. Uh, Fortunately, it never flooded. I think they're due for one, but they built these huge aqueducts basically where the water can flow through. So hopefully it's safe. Very good.
Yeah, all
Thank
right.
you for the question.
Yeah, your answer did answer my question, so I appreciate it. Thank you.
My pleasure. Thank you. What other questions we have?
I have a question. Professor Blackman, I was just wondering, even though the opinion required Congress take action or speak on the issue, do you think Congress could have already spoken on the issue since Section 18 USC 2383 is still good law?
Right. So for those who don't have the U.S. Code memorized, like my good friend over here, uh, Section 2383 is a federal criminal statute. Okay. And it makes it a crime to engage in insurrection. What a lot of people don't know is that this statute was actually passed before the 14th Amendment. President Lincoln signed into law. So what Seth and I have argued is that this statute 2383 did not originate as enforcement legislation, but perhaps they can be viewed as enforcement legislation. In other words, it's a statute. It references insurrection. It came around, a couple years before the 14th Amendment, but it gained new meaning after the thing was passed. Had Jack Smith or had someone indicted Trump on January 21st of 2021 for insurrection, we'd have a final judgment by now, right? All this nonsense, I should say nonsense, but all this other stuff, but oh, he trespassed, and oh, he smashed a window, and right, and oh, he put his feet on Nancy Pelosi's desk. That should never been the priority, right? That was all nibbling at the edges. The priority, if at all, was to get Trump, but they didn't, and they couldn't, and I don't think anyone could be gotten. No one's been charged with insurrection. Maybe the feds thought they couldn't make the conviction. I don't know, but no one's in charge. But instead, Biden waited, or Garland waited 2 years, and then finally appointed a special counsel, who now we have to worry about this as the primary season is ongoing. Now they're moving as quickly as they can, but they waited too long. I think a 2383 conviction would have probably been good enough. If they convicted Trump of this entire thing would have been over. We would never have this election. I think he'd be politically dead. Maybe not. Who knows? But instead, they brought this sort of silly charge about the documents in Mar-a-Lago, and they brought the Stormy Daniels thing. They throw this lawfare at him, and I think nothing's actually sticking. What other questions can I answer?
Hi, Professor. Thank you for coming. I
Hello.
just have a question, and you touched on it in your talk, but if in an ideal world, or your ideal world, how would you have wanted the case to come out, or like the Supreme Court to write their opinion?
Well, I would have liked them to use my ideas. That would have been nice. I don't always get that. I'm a big critic of the court, and I'm well aware that makes it less likely to use my ideas, which is fine. But at least I'm sure they read them. What I think the court probably should have just said is the president is not covered by Section 3. This case goes away. It may not be satisfying, but it would cleanly resolve the case. And also, I think there's a lot of authority behind it. Or they could have said we followed Griffin's case and you need legislation, but they sort of made up this middle rule that's making really no one happy. Yes, in the front.
Yeah, question. This is sort of a general question, so you can just say a little bit of something about it. It doesn't require a really specific answer, but um, as someone who's sort of an originalist, we're oftentimes thinking about the founders, but a lot of people have noted that these sort of post-Civil War amendments really sort of change the Constitution. They sort of change, a lot about the nature of the government. So what do you think was the intention of the writers of the 14th Amendment with that clause? Was it a very specific problem related to the Civil War of like disqualifying Confederates, such that the clause was really intended to have sort of ramifications beyond that, or does it have really more general and lasting ramifications? And like, what were those? Like, who were they intending to keep out of office?
Really good question. The 14th Amendment was enacted in 1868 in the wake of the Civil War and was passed in this very brief window where the so-called radical Republicans had large majorities in Congress. And most of the southern states were not really part of the Union. If they were basically headed by Reconstruction governments. And many of the southern states were only readmitted to the Union on the condition that they would approve the 14th Amendment. So it's not clear that this amendment had the sort of national buy-in that it usually needs to have an amendment to the Constitution, right? It was passed in this very brief window. And by the time we get to the 1870s, that window closed. And I think people realize, like, what did we do, right? What did we just pass? How did we just change the entire structure of the federal government? Because before this, the federal government didn't really have much authority over the states. The states had broad latitude to do whatever they wanted, and that led to slavery and the like. So there were problems there. But what did they do? So one case you may have read about is the slaughterhouse cases, which was decided was 1871 or 1873, might be off by a year. 1871, I think. And the slaughterhouse cases, I'm sorry, 73 was right the first time. And the slaughterhouse cases involve the privileges or immunities clause of the 14th Amendment. And this is sort of an obscure provision that you don't learn about much. And it says the states cannot abridge the privileges or immunities of citizens of the United States. Right? What are these rights? If you look at debates on the 14th Amendment, there's some discussion, some very broad rights. It might include the Bill of Rights. It might include other types of unenumerated rights. There's a lot of stuff that was covered. But the court read it very narrowly in this decision. They sort of strangled the clause in its crib. And for the longest time, I've said, oh, that's wrong, that's wrong. And I've sort of, I don't know, maybe come around to slaughterhouse later in my life, thinking that these were pragmatic judges. They didn't know what the heck to do with this amendment. The political support wasn't there. And they said, okay, we're going to just read this narrowly and not deal with it. And in some regards, that became the original meaning of the 14th Amendment, right? Within a year or two of its ratification, they sort of read it so narrowly that it didn't have much juice and people sort of moved on with it. And maybe Section 3 is in a similar boat. This was viewed as a very important provision that never really did much. Almost immediately after Section 3 went into effect, Congress granted these broad amnesties saying, all right, this is a screw up. Let's start letting foreign Confederates hold office. This was a mistake. We shouldn't be doing this. So Chase's decision, I think, is sort of consistent with that normal, like, what did we just do? Let's slow down. Let's be a little more cautious. This is not going to be good for the Republic. And I think if I can say it, people don't like when I say this, but the original meaning of the 14th Amendment has some pragmatism baked into it with decisions like Slaughterhouse and Bradwell and Cruikshank and, maybe even Griffin's case is one of them. And because his decision is so contemporaneous, I think they form part of the meaning of the Constitution, either through original meaning or liquidation. And that's sort of where I fall down. So I think the 14th Amendment's framers wanted to do a lot, and they simply did not get all that done.
Thank you.
Anyone else have a question? Alright, I'll go again. So Professor, what makes section 3 special? What I mean by this is most of the other provisions of the 14th Amendment were interpreted as being self-executing. So what makes section 3 different from like equal protection?
Your question's half right. How are provisions of the Constitution self-executing? If the government takes action against you, right, that is subject to the Constitution always. And you can always raise the 14th Amendment as a defense. That is, if the government prosecutes you based on your race, right, or they target you based on your religion, or they violate your free speech, you can say, aha, you're doing this because of, protected rights. I can raise the 14th Amendment. In that regard, the Constitution is always self-executing. But when you seek affirmative relief, like Section 1983, you need a statute. When you seek affirmative relief against the government, affirmative relief, not monetary or damage, doesn't matter, you need a statute. So the 14th Amendment's never self-executing when it's used as a sword, but always self-executing when used as a shield, right? There is no tension, right? In that regard, Section 3 operates as the same as all the other ones. And I think this is a pretty obvious part of federal courts, but people just don't see because they like saying, oh, I learned in common law, it's self-executing. It's only half right. Good question.
Well, if we have no further questions, I think that's it. Oh, you do? Okay.
Yeah.
Please.
So, thank you, Professor. I wanted to flesh out a hypo you gave us a few minutes ago. So if Trump was to win, and then immediately upon taking office, all these judicial challenges are launched against the legitimacy of his presidency, what kind of instability and turmoil can we expect as just everyday Americans in terms of the president and the way he would affect our lives? And given, I know it's kind of a difficult question, given it's very unprecedented, but I would love to hear your take on the situation.
I'm sorry, you broke up a little bit. Could you repeat the question? Just the middle part. I think it broke just a little bit.
So what kind of instability and turmoil could we expect if a bunch of judicial challenges were launched against the legitimacy of a future reelected Donald Trump?
Really, really bad. So, I mean, imagine if a somewhere holds that Trump is not really the president. That means that the military does not have to obey his orders. That means that his pardons are invalid. That means any bills he signed are not really law. That means any executive orders he signed lack authority. It's really problematic. I suspect any judge with a nickel of common sense on his or her head would basically send this case right to the Supreme Court. Whatever ruling they make, they stay it. But if some judge decides to play God and says, aha, I'll decide the presidential election, then we have a problem.
Thank you.
So, and any more questions? Final call. No? Okay, that's it. Thank you, guys. Thank you, Professor Black.
Thank you so much. Thank you so much, everyone. Have a wonderful day.
You too.
Yeah.